Hey, what's up, y'all? It's Hookah Anonymous, and you are now rocking with Mickey Truth. She live up to her name, not the fame. So make sure y'all subscribe to her channel and stay updated on what's real.
So what's up, y'all? It's your girl Mickey Truth, aka the Queen of Paperwork, and I am back with another video. As always, all information contained in this video is for entertainment and educational purposes only. All information used in this video is per the Fair Use Act, and any conclusion that you draw is on you, not me. So let's get it. And y'all already know where we going. Let's get to the word. I don't know about y'all, but one of the stories I've been wanting to get more information on was the one murder case that we know for sure King Von actually faced in his lifetime, right? Actually got arrested, went to trial. And I'm here to break it down today. If you are not, familiar with what I'm talking about, May 29th, 2014 is where we're going to start off with this. The murder of Malcolm Stuckey. It is said in Chicago, and this is according to STMW, a Hazel Crest man is the second to be charged in connection with a shooting a South suburban man to death and wounding two others almost 2 months ago in Inglewood neighborhood. Davon Bennett, 19, faces one count of first-degree murder and 2 counts of attempted murder, all felonies in the connection with the May 29th shooting that happened in the 5700 block of South LaSalle Street. Police announced early Tuesday. 3 men were on the porch there around 6:10 p.m. when someone walked up out the gangway and fired shots. Police said at the time. Malcolm Stuckey, 19, of the 16,000 block of Carrington Drive in South Harlan, was shot in the head and pronounced dead at 10:35 p.m., according to police in the Cook County Medical Examiner's Office. A 23-year-old man suffered gunshot wounds to the mouth and leg and was taken to the John H. Struger Junior Hospital of Cook County in serious condition, and a 24-year-old man took himself to St. Bernard Hospital and Healthcare Center with a gunshot wound to the foot, police said. Bennett, of the 16,900 block of South Jardone Avenue in Hazel Crest, was later identified as the shooter. Police said he is scheduled to appear in bond court on Thursday. Bennett is the second man arrested in connection with the shooting. Michael Wade, 23, of the 7200 block of South Chaplain Avenue, has also been charged with 1 count of first-degree murder and 2 counts of attempted murder, authorities said. Cook County Judge Maria Cezo, ordered Wade held without bond Tuesday, according to previous Chicago Sun-Times report. He is next scheduled to appear in court on August 12th, and we are referring to 2014. So, who is Big Mike? Some of y'all may be familiar with that name because normally that's the name that we hear in connection to this case. And allegedly, right, being a person who snitched on King Von, okay? So, Big Mike is also known as Michael Wade, and this is his actual arrest intake for July 22nd, 2014. Oh, let me correct that. He was arrested July 20th, 2014, and it says released from the Chicago Police Department on July 22nd, 2014. Now, how it go? How it go, y'all? Well, according to the song, How It Go by King Von, it's a part in there that said, gave him 28 years because the ninja wouldn't close his lips. And in my opinion, I think he's talking about Big Mike, aka Michael Wade. Why is my opinion that? Well, according to the documentation, Big Mike was actually sentenced to 28 years in prison for his charges of aggravated battery with a firearm. Yes, 28 years. Whew, that's a long time. Okay. Well, let's get into the actual case and trial of Davon Bennett, aka King Von, and Big Mike, aka Michael Wade. Okay. On appeal, now this is from the appeal documents for Michael Wade. It says the defendant, contends the trial court erred when it denied his motion to suppress his statement to police because the statement was obtained through police coercion. The defendant contends the state failed to prove him guilty beyond a reasonable doubt because it failed to establish that the victim was shot, and if he was, that the gunshot was fired by the defendant rather than his co-defendant. We affirm the trial court's denial of defendant's motion to suppress, but reverse his conviction for aggravated battery with a firearm, and remand for resentencing on a lesser charge or lesser offense of aggravated discharge of a firearm. That's a big difference. And I'm going to get to that at some point of why that's a big difference in sentencing. All right. Now, here it goes. This is the details that were provided. It says the defendant and co-defendant Davon Bennett were tried on charges of first-degree murder and aggravated battery with a firearm for the May 29, 2014 shooting incident that resulted in the death of Malcolm Stuckey and injuries to Marquise Carpenter and Timothy Robertson. The defendant was convicted of aggravated battery with a firearm for shooting Robertson, but acquitted of the murder of Stuckey and aggravated battery of Carpenter. Bennett was acquitted of all charges. And, King Von definitely has spoken on that. Okay. Now, the thing is this. If that was going on at trial, why he told? Like the song by King Von said. Why did Big Mike tell? Well, according to his appeal, it says, prior to trial, defendant filed a motion to suppress statements he made to police during a video recorded interview following his arrest. In his written motion, defendant alleged that his statements were involuntary because they were obtained through psychological and mental coercion by the detectives who interviewed him. Defendant stated that he has been held in custody for over 30 hours and repeatedly questioned by several detectives. Okay. Defendant asserted that Detective John Halloran repeatedly suggested defendant should minimize his role in the offense by incriminating Bennett before Bennett incriminated him. That's technical police tactic. Okay. Halloran also implied that if defendant spoke with him, the trial court would favorably consider defendant's corroboration while determining a more lenient sentence. Defendant further alleged that Halloran repeatedly violated his personal space by sitting within inches of him or standing directly over him while yelling profanities and threats at him. Defendant argued the totality of the circumstances rendered his statements involuntary in violation of his constitutional right. Whew, that was a lot to get through. So listen, basically they say, he made me do it. The police made me do it. What y'all think about that? The police made him tell. Hey, I've heard worse situations. But nevertheless, you have the right to remain silent, or do you? Okay, because it says at a hearing on his motion to suppress, the state presented a stipulation that defendant was arrested on July 20th, 2014 at 3:06 p.m. While in custody in the interview room, defendant slept on a mat on and off for 12 hours, was allowed to use the bathroom numerous times, and was given food to eat at different times, including a sandwich, chips, and McDonald's, and was given numerous bottles of water and cigarettes. The state presented another stipulation to the foundation for video clips defense counsel was going to play, and stated defendant was not alleging any threats or coercion occurred outside the video clips being shown in court. So basically they said, hey, you ain't say that when it was going down. Now all of a sudden you want to say that. But let me tell you, it must have been getting hot in there, all right? Because at trial, now I want to let this set on your spirit. One thing I don't know, was the trial together? Because if it was, King Von is sitting through all this. And I kind of feel like it was, but I can't confirm that. Y'all let me know in the comments what y'all think, or what do y'all know? Was the trial together? Because it said here, defendant played for the court 7 video clips inserted from the video recording while he was in custody in the interview room. This court viewed those clips. In the first clip, police bring defendant into a room handcuffs about 4:40 on July 20th. Now, for those who don't know, King Von was not arrested until July 22nd. Okay, so 2 days after this. All right. Now, it does say here originally the defendant repeatedly denies any knowledge of or involvement in the shooting. Okay. In another clip, it is said that defendant is laying on a padded mat on the floor when the detectives come in, and they advise the defendant of his Miranda rights. So he is Mirandized, because at this point, if we follow protocol, like y'all say, he should have asked for a lawyer. However, according to this, the defendant continues to speak with police and deny any involvement in the shooting. Each of the 3 interactions lasted 2 to 2.5 minutes. Now, in the 4th clip, okay, this is where things get a little, you probably should have exit stage left with saying, let me just get my lawyer. Because it says that the detective tells the defendant that people at the party where the shooting occurred knew Bennett and were talking to him earlier in the day. Okay. Defendant asked the detective, "You're saying that he knows the people he was in the party with?" The detective says, "Yeah." Defendant, meaning Big Mike, "I didn't know all that." Defendant continues to deny any knowledge of the shooting. Defendant tells Murray he gave a statement in his prior armed robbery case and pleaded guilty. Defendant states that if, okay, if he was involved in this shooting, he would have requested a lawyer and not spoken with police. The interaction lasted 7.5 minutes. So, little side note. I mean, at this point, you literally say what it is that you should do. But so far, nothing has been said other than, if. But does it stop there, right? Well, what if, right? Now, if we keep on going, it says a sixth clue. They come back into the room, all right? And it says here, the detective tells the defendant that if he does not give up Bennett, we're going to end this case on you, okay? Then he says, if Bennett testifies against you at trial, the defendant then testifies against Bennett. The prosecutor will use the defendant's prior armed robbery conviction to argue that his testimony is not credible because he's a convicted felon, okay? They continue to go on, talk shit, fuss at him, cuss at him, right? And now, this is where shit gets real, because this is where he should have been at the stage left. However, okay, the defendant then goes to tell the police, "Y'all ain't trying to help nobody," okay? Said, "Listen, even if it was Bennett's idea and Bennett was the shooter, I'm still going to jail." Okay? The detective said, "You still have a problem. You're absolutely right." Now, the defendant then said, "At the end of the day, y'all don't sentence me, the judge do." Now, I thought, well, maybe King Von had it wrong. Maybe he had it wrong because it doesn't sound like he's saying nothing to implicate him, right? Now, he continues to talk to the police. He continues to answer questions. They have a dialogue, right? Now, the detective does say here that if the police have the facts wrong, it's up to the defendant to straighten it out, or the police will go with the information they have. Now, the defendant asks this question, and the question is, if he tells them what happened, will that make a recommendation to the judge stating that he cooperated? Okay, the defendant states, "I know at the end of the day, either way it go, I'm going to have to do time." The detective tells the defendant, "I can't make you any promises, nor can he, but they will ensure his cooperation is noted." The detective says, "I can't make you any promises, okay? And it will be up to the prosecutor to decide what they want to do with you." Then they says, "Now, listen, I believe the shooting was gang related, and it was easy for the police to identify Bennett by his nickname." Now the defendant begins to talk and says he might be able to assist the detectives with another murder. Another, sir, you already here on one, not another murder, another murder. Now, the detective said, "This isn't let's make a deal here, okay?" The three men are laughing together as the defendant, the three men, meaning the two detectives and Big Mike, are laughing like they're friends, okay? And they said, "I know it ain't let's make a deal, and I'm going to jail regardless. If it would be helpful for me, just to give you some information about the shooting and another murder, right? Let's talk about it. Maybe you might need this, right?" So the detective stated he would tell the prosecutor that he cooperated with them in this case and was helpful in another case after they verify any information he gives about that unrelated murder is truthful. This interaction lasted about 8 minutes. Ooh, ooh, It's starting to really kind of get there. Now, as the trial comes forward, now it does not specify what information was provided on another murder. What case was it? Could it have been KI murder? Could it have been? I mean, at this point, who knows? Because remember, it was all these rumors about serial killing. I mean, I don't know. Again, but hey, that's what's in the paperwork. Now, the trial. One thing I wasn't aware of, or I guess I assume that King Von got off because Big Mike chose not to testify, but he's not the only witness that actually testified or was supposed to testify at trial. Okay, so let's get into the trial. It says that Marquise Carpenter acknowledged he had two felony convictions from 2011, possession of stolen motor vehicle and possession of cannabis, a pending criminal contempt charge for failure to appear on a prior case. Now, this is, okay, a person that was at the party and, okay, also a person that got injured, and so one of the charges. So this is a victim that's on stand at this point, okay? And it basically outlined what they were doing, okay? Now, it does say here that later that afternoon, Bennett, who was CJ's friend, arrived at the party in a two-door gray Allura driven by Jasmine Mitchell. Carpenter identified Bennett in court. So now I just answered my own question. It was a joint trial, okay? Mitchell went on the front porch and began flirting with Robinson. Bennett was standing outside the house talking with CJ about 5 feet from Carpenter. Bennett repeatedly looked at Carpenter, who looked back at Bennett. Carpenter had a 9mm handgun in his back pocket that he carried for protection. About 15 minutes later, Carpenter observed Bennett retrieve an unknown object from inside the Allura. Bennett placed the object inside his front waistband and covered it with his shirt. Carpenter believed the object was a gun. Bennett returned to an area outside the home and continued speaking with CJ. About 15 minutes later, Bennett and Mitchell left CJ's house in Allura. Shortly thereafter, Malcolm Stuckey arrived at CJ's house to meet with Carpenter, who was going to sell Stuckey's vehicle for him. Now, that's just hearing that part because we already know kind of what's about to happen next. Nevertheless, he had just arrived. Now, following the video clips, right, that the defendant played, and detectives testified that he interviewed Jasmine Mitchell on July 17, 2014, which is before King Von and Big Mike is arrested, and said Mitchell told Garza she was in the vehicle with the defendant on the night of the offense, and she identified the defendant in a photograph. Based on the information from Mitchell, police arrested defendant. Defendant was in custody in the police station from July 20th to July 21st, 2014. Garza and Batali, or however you pronounce it, were the first detectives to interview defendant. Defendant participated in 3 lineups that evening, viewed by 3 eyewitnesses to the shooting. None of the eyewitnesses identified the defendant, meaning Big Mike. Okay. Now, Jasmine Mitchell, okay, does acknowledge on stand that she was granted immunity in exchange for her testimony. Mitchell and Bennett were close friends, and she met defendant through Bennett. She identified both men in court. On May 29, 2014, Mitchell drove Bennett and defendants to CJ parties in her silver Allura. She parked in front of CJ's house. Mitchell and Bennett exited the vehicle. Mitchell went on the front porch and talked with Robinson, who was wearing an orange shirt. Bennett went inside CJ's house, and it continues. And we have heard a lot of these stories. However, right, it did say that Bennett directed Mitchell to drive to Parkway Gardens, apartments on 65th Street and King Drive, because he and the defendant wanted to buy weed, but did not have enough money. At the apartments, the 3 of them exited the vehicle. Mitchell spoke with someone she knew who was outside. She did not know where the defendant and Bennett went. About 10 minutes later, defendant and Bennett returned to Mitchell's car. The 3 of them re-entered her vehicle and drove back to CJ's house. Bennett directed Mitchell to park on another street. Bennett and defendant exited the vehicle while Mitchell remained inside on her phone. A few minutes later, Mitchell heard about 10 gunshots. She ducked down inside her vehicle because she did not know where the shots were coming from. Bennett and the defendant came running back and re-entered Mitchell's car. She drove them back to 65th Street and King Drive, dropped them off, and went to her grandmother's house. Now, it does say on cross-examination, Mitchell confirmed the defendant was with her and Bennett the first time they went to CJ's house, but defendant remained inside her vehicle. They returned to the party later to buy weed. Mitchell did not see the defendant or Bennett with a gun. So, that's a lot going on. Okay. Now, another witness took the stand, which was CJ's mother, and basically just said, I saw King Von at the party. However, I ain't see him do nothing. But I told him, like, I don't want none of that. So, you know how it is with mamas. They be like, Now, on July 21st, 2014, according to the detective Moreau, or is that Moreau? Murray, my bad, Murray. He had 2 conversations with the defendant, which is Big Mike, in an interview room at the police headquarters. The first conversation included Detective Castle, and the second conversation included Detective Holloran. Both conversations were video and audio recorded. The recorded conversation was published to the jury. Ooh, so that means King Von. Ooh. Now I understand why he wrote these songs, because he heard it all. right? Now, it does go into saying again that he was Mirandized for sure. Okay. Now, the defendant, according to the well, you know what? Should I say according to the detective? Because they heard the audio, but nevertheless, according to the detective's testimony, it said the defendant asked for time to think about it, which he is given. Defendant tells the detective that he was not with Bennett and Mitchell the first time they went to CJ's house, although, Mitchell said he was. But anyway, Mitchell called defendant and said she and Bennett were going to pick him up because Bennett got into it with somebody and needed defendant's help. So that sounds like they knew each other. Over the phone, Mitchell and Bennett told defendant someone was eyeballing Bennett at the party, and a couple men were whispering with each other, which made Bennett nervous. Bennett wanted defendant to return to CJ's house with him to be his muscle so no one would fuck with him. Okay. 10 minutes later, Mitchell arrived in a silver Allure with Bennett in the back seat. Defendant got in the front passenger seat. This is weird. Okay. I mean, like, I'm confused at this point, right? Now, it continues to go through his statement, stating that defendant states he and Bennett exited the vehicle, walked through a field and a gangway. Bennett was walking in front of the defendant. They did not cover their heads. Defendant states that he always carries his gun, a Glock 40, and Bennett also had a gun. As they exited the gangway, defendant saw Robinson, who was wearing an orange shirt and long dreads. Robinson looked at Bennett with a shocked expression. Robinson, Bennett, and the defendant stared at each other for about 10 seconds. This is detailed, okay? Robinson then ran northbound down LaSalle Street. Bennett yelled at him, "What you running for?" I kind of like in my mind hear King Von voice saying that, rest in peace, King Von, but I'm just saying I damn sure heard that just now. But anyway, when Bennett reached the front of the house, he started shooting. When the defendant reached the front of the house, he saw a man fall to the ground. He did not see Bennett shoot that man. Bennett was not shooting at Robinson. Defendant observed Bennett chasing another man who jumped over a banister. Defendant began chasing Robinson down the street and shooting at him. Defendant fired 16 shots at Robinson. Now, I will say this. Robinson didn't die. So that's like, fuck. What kind of marksmanship is that? Anyway, emptying his gun. Defendant states he could see Robinson was hit because of the way he was running. Defendant could not tell where Robinson was hit. Defendant stands and demonstrates for the detectives how Robinson was limping as he continued running. Robinson was holding up his pants as he ran. Listen, I kind of want to see this video because, like, you're literally showing, like, this is crazy. This is crazy. The fitness states that because his gun was empty, he ran back through the gangway headed to Mitchell's car. He could still hear gunshots as he ran. The defendant observed Bennett circling around the house. Bennett stopped at the alley and fired 2 more shots at a man laying in the grass with blood coming out of his mouth. The defendant and Bennett re-entered Mitchell's vehicle and Mitchell drove away from the scene. The defendant threw his gun into the lake later that day. Whew. Now, on cross-examination, there's really not much they can say, right? But they do say that the detective does say the defendant was not identifying the lineup, okay? And that when he discussed the lineup during the interview with, it was an evidence play. So they made it seem like he was, but it really wasn't. And technically, that's not against the rules. But anyway, right? Also, they did acknowledge that he was in that room for about 30 hours, right? When he made the statements. Then the detective does deny that they implied to the defendant that he would receive any leniency if he cooperated with them. So nevertheless, at this point, definitely provided statements. Okay, now it says at the end of it, the defendant was given a mattress that police are required to provide people who are in interview rooms for a long period of time. So it sounds like they definitely, went with what they were needing to do as far as their guidelines and procedures so far. Right now, the jury found the defendant, Big Mike, guilty of aggravated battery with a firearm to Robinson, but not guilty of the murder of Stuckey and aggravated battery with a firearm to Carpenter. Okay. Defendant filed a motion for judgment notwithstanding the verdict or a new trial arguing that there was no evidence Robinson was injured in all this and all that, right? Nevertheless, he was still sentenced to 28 years. Now, again, that's how I go. And these are some lyrics to the song. So on appeal, okay, he challenged everything, okay, including being coerced, saying, "Hey, I was under distress. Y'all had me in this room for 30 hours. I was dependent on y'all for food, water, bathroom. I mean, it's like this is torture. Y'all basically torture me, right? Listen, not so quick. The state say, yo, listen, I hear all that, but he was asleep for about 12 other hours, right? He used the bathroom multiple times. He was giving food. He was giving bottles of water, cigarettes, okay? He was giving all that. He understood what was happening. This wasn't his first rodeo, okay? And again, they say, yeah, he cussed at him, raised his voice. But what? What threats was done? I'm just saying. Should have been used to it. Now, again, according to the appeals court, the record reveals the defendant's confession was not coerced by detectives and therefore was voluntary. So at the end of the day, he knew what time was going on. Now, with the claim that he was promised something, okay, and all that, according to the actual video, shows that nothing at all was promised, okay? It actually shows that the detective told the defendant he better start playing ball with them. And the defendant stated, y'all ain't lying. Y'all ain't trying to help nobody. My bad. Y'all ain't trying to help nobody. And it goes like that. So it was just, what they normally do. Now they continue to go on to say, hey, you basically signed up for this by talking with us and all that. So it continued. So they basically shot down that it was coerced, shot down that they had any violations to none of that. Okay. It even says that at one point he sat next to the defendant on the bench for a few seconds, mimicking defendant and Bennett sitting next to each other at trial. At that point, you're talking with them. Like, what else you thought they was gonna do, right? So again, I just don't know. Now, the detectives also said that the defendant said he did not give up Bennett. The police would end this case for you. Again, they have already stated at the end of the day, they did evidence ploy. So it's kind of one of those guys. Again, you can try to go against, okay, police or whatever and all that, but you got to keep it real. Don't people be playing games and you think you playing the game, they playing the game on you. Now, this is where things definitely take a change, because to prove, and this is according to the Supreme Court, to prove defendant guilty of aggravated battery with a firearm as charged in this case, the state was required to show that in committing a battery, he knowingly discharged a firearm other than a machine gun or a firearm equipped with a silencer and caused injury to another person. In this case, that he shot Robinson about the body. Okay, they viewed in light most favorable to the state, so they show that they did do that part. Okay, because they show like, hey, you even said you emptied your clip. Okay, we have all these 40 caliber shell casing that you said you had a 40 caliber. Okay, like at the end of the day, now this is where he finally take a win, because he must take some L's. Okay, now the win was this, is that in the state's case, okay, the evidence establishing that Robinson was injured as a result of being shot by the defendant was scarce because Robinson did not testify. The state did not produce any medical evidence to establish that Robinson was injured. There was no eyewitness testimony as to Robinson's injury. There was similarly no circumstantial evidence that demonstrated that injury occurred. So basically, they had nothing, okay? Nothing. No technician testified about nothing. So that was the mistake on the state, okay? And I'm just gonna say that. Now, it later just come on to say, hey, at the end of the day, for these reasons, we affirm the trials court now to deny the suppression of the statements and all that. But we're going to go ahead and reverse the defendant's conviction for aggravated battery with a firearm, enter a judgment of the lesser offense of aggravated discharge of a firearm, and remand for resentencing of their findings. So at the end of the day, although you told for sure, your statements is there. Although you told, guess what? The 28 years turned to 11 years. That is a big difference, okay? 11 years, a big difference. He took a win. So, Wilby might be released next month. Well, that's what they say, because according to the Illinois Department of Correction, his projected parole date is October 12th, 2023. Now, if for some reason he does not get parole, his projected discharge date is October 12th, 2025. So nevertheless, right around the corner, more closer than one than the other. However, that is the story of the murder charge of Malcolm Stuckey for King Von and Big Mike. And I hope you enjoyed it. So until next time, make sure you like, comment, share, subscribe, tell a friend and pull up on your girl Mickey Truth. And as always, go over to MickeyTruth.com and get you that merch, because your girl stay with that word. I've been talking a lot. But until then, Holla!
Bye.
Coming from where I come from, they doubted me, but I came up. I made it through the storm, trying to conquer the world. I made it through the storm, trying to conquer the world. Coming from where I come from, they doubted me, but I came up. I made it through the storm, trying to conquer the world. I made it through the storm, trying to conquer the world.
Good reporting ass Mickey.
We love you, Mickey.